it would prove that, I think, hopefully useful in terms of our discussions here today and our examination of the various issues. I'm going to start by looking at the basis of the exclusion clauses in terms of convention, refugee status, look at some recent research concerning the exclusion clauses itself. There's been some arguments and theses presented with respect to the growth of the culture of exclusion within Canada, and also some analysis and discussion with respect to problematic trends in terms of the analysis of Article 1FA. And I'll use those as a kind of foil in terms of the work that we're doing with respect to war crimes and refugee status. So looking at the basis of the exclusion clauses and convention refugee status, I think the fundamental premise it's important to emphasize in terms of the exclusion clauses themselves is that convention refugee status is not going to be granted to those who are already receiving, of course, international protection from other UN agencies or from states themselves, or who have committed such serious criminal offenses as to make them ineligible to receive convention refugee status. And if one looks at the Office of the United Nations High Commissioner for Refugees handbook on the procedures and criteria for determining refugee status, in fact divides this into three categories: persons already receiving United Nations protection or assistance, persons not considered to be in need of international protection, and persons considered not to be deserving of international protection. And that's been, I think, a term that some people have taken issue with, undeserving of international protection. Some would argue with the advance of international human rights being universal, that one cannot really take those away from individuals. So the term undeserving has been, I think, an issue that has been raised by some commentators and researchers as being problematic. If you look at the relevant paragraphs in terms of UNHCR handbook, and I know we're going to have a presentation that will examine this in more detail later today, I think it's important to keep in mind some of the basic principles with respect to the exclusion clauses themselves. And one is that if you look at 147 and 149, you'll find that in fact it pronounces that the competence for deciding whether the exclusion clauses are applicable is the responsibility of the state parties. It's important to keep in mind, of course, that 51 Convention and 67 Protocol are treaties, and it's the states that have the obligations in terms of applying those particular treaties. So it's the responsibility of the states themselves with respect to the deciding when the exclusion clauses ought to be applied. There's no formal proof of previous penal prosecution required with respect to the application of the exclusion clauses, which I think is an important aspect to this. And it's raised various concerns, perhaps, in terms of the standard of proof with respect to the application of Article 1F. And one of the things that's emphasized by UNHCR is that because there are such serious consequences with respect to exclusion, that the interpretation of the exclusion clauses must be restricted. If you look at paragraph 150, which is most relevant in terms of what we're examining today with respect to Article 1F, it notes that crimes against peace, war crime, crime against humanity is defined under the international instruments that have been drawn up with respect to this. In fact, specific reference is made to the 1945 London Agreement and the Charter of the International Military Tribunal. And if you go to the annexes 5 and 6, they define, those are the relevant portions of the agreement and the charter, and they define in specific detail what constitutes these types of crimes for the purposes of Article 1FA. If you look at UNHCR's most recent guidelines with respect to the exclusion clauses, and those are of 2003, which states specifically, of course, they're intended to complement the UNHCR's handbook and the paragraphs that I've already referred to. Paragraph 2 of the guidelines state that certain acts are so grave as to render their perpetrators undeserving, there's that controversial term again, undeserving of international protection as refugees. And they also, at the same time, however, and I think this is important to emphasize, the exclusion clauses must be applied scrupulously to protect the integrity of the institution of asylum. And they make reference to the relevant executive committee conclusions with respect to that. It's also important to note as well in paragraph 8 of these guidelines that there may be obligations under international law that require the persons that are being excluded be criminally prosecuted or extradited. And I think that's something that's worth bearing in mind as well as we go on through the day in terms of our discussions. With respect to some recent research concerning the exclusion clauses, I want to look at specifically 2 articles that were recently published in the International Journal of Refugee Law. One by Asha Kaushal and Catherine DeVerne, The Growing Culture of Exclusion Trends in Canadian Refugee Exclusion. And they actually undertake a very thorough and detailed analysis in terms of cases that have emerged under Article 1F that encompass A, B, and C under Article 1F. And they examined the decade between 1998 and 2008, and using the Access to Information Act, they actually received from the IRB some 757 cases that involved exclusion, and they point out that 364 of these particular cases dealt with Article 1A, 1FA, excuse me, or some combination of Article 1F, B, and C with A. So about half of all of the exclusion cases that were done over that 11-year period were cases involving Article 1FA in whole or in part. They also drew upon the commercially available databases as well as the databases that are online with the federal court, and they identified some 270 relevant cases as well. But I think the point that I want to underscore that they emphasize is that it's virtually impossible to get an accurate count of the number of cases in which claimants have been excluded. And this is one of the issues that we've been grappling with the Canadian cases in terms of our site. The problem being, they specifically emphasize that not all exclusion cases are publicly accessible. And that is a problem in terms of actually getting a count. Now, it's important to keep in mind, of course, as all of you I'm sure are aware, that cases that are appealed at the federal court can be struck down, and then they're sent back for redetermination by the Immigration and Refugee Board. A decision could be rendered, and again, exclusion can be upheld by the IRB on a de novo hearing, and then it goes back to the federal court again, and the federal court might in fact decide to certify a question, say, then it goes to the Federal Court of Appeal, then it goes back to the IRB. So the process, in theory, could go on for some period of time. Then that complicates, in fact, tracking the number of Article 1FA cases. And I had an interesting discussion this morning with a colleague from the Netherlands, and I indicated, yes, you can count the number of decisions that have been rendered by the IRB in terms of Article 1FA cases, likewise with the federal court. But does that represent, how many actual claimants does that represent? It could represent, obviously, less claimants than the number of decisions that have been rendered. And keeping track of these individuals where Article 1FA has been raised as an issue is not that easy. And they make that point in terms of actually trying to identify accurately the total number of Article 1FA cases themselves in terms of individuals and in fact in terms of decisions. They also draw a number of conclusions from their data set, which I think is important to underscore here as well. They indicate there's a growing number of refugee claimants that are excluded, and that in fact this group is expanding. So it's not only the total number of cases, but the types of individuals that are being excluded is expanding. So they point out that in fact it's no longer simply senior officers, people that are in high authority, but it also includes the ordinary soldiers. They point out that it's not only the bomber, but the accomplice, the planner, as well as the fundraiser. So the total number of Article 1FA cases is not only expanding, but the net, the individuals that are being captured under Article 1FA seems to be expanding. They also point out that decision makers, refugee law decision makers on these cases are increasingly not accepting violent means, even when it's directed towards political ends. So the tolerance in terms of involvement politically, in terms of violent means, is diminishing, if you will. And they also suggest that there are two converging trends that perhaps contribute to this. And one is the securitization of refugee law. And this is followed, of course, in the wake of various terrorist attacks that have been taking place around the world, and specifically since 9/11. But also the developments that have taken place in terms of the Great Lakes, ex-Yugoslavia, Sierra Leone, Sri Lanka, and so on. And what this has created is a situation where perpetrators as well as victims have been seeking asylum. So these two converging trends, they would argue, have contributed to the number of claimants. I think that probably stands to reason. The other study that I'd like to draw to your attention is Pia Zambelli's study in terms of problematic trends in terms of the analysis of state protection with Article 1FA. She also looks at state protection, but we're not looking at that particular issue area today. And she suggests that, like the previous researchers, scholars, that in fact there's been a proliferation in terms of the number of people that are being excluded under Article 1FA. And in fact, she suggests that this is primarily due to the deficiencies in terms of legal analysis, or the framework of legal analysis, and especially with respect to the IRB decision makers, and maybe Nancy and others want to comment on that later on. But Pia Zambelli is not only a practicing lawyer, but a noted author in the field, but she's also a previous member of the Immigration and Refugee Board. So she's coming at this very much from a personal perspective as a practicing lawyer. And in fact, the period of time that she's looking at is the last 15 years as opposed to the last 11 years. And she's drawing primarily in what I would say is the traditional scholarly legal analysis by looking at the precedential cases and then distilling from that the basic principles that have been established with respect to the interpretation of the exclusion clauses, in particular 1A. But her data set is really more anecdotal, but she does draw upon the available cases with respect to the Federal Court of Canada. It's available on the website, and she does indicate that there has been a spike in terms of the number of cases that have come before the federal court. And if I'm not mistaken, that was around 2006, 2005, where she identified something like 21 cases that came before the federal court. In essence, she argues that with respect to exclusion of Article 1A, it was, from her perspective, intended for persecutors and serious international criminals. But in fact, as Michel and Deverne have argued, that it's now covering those at the lower echelons in terms of people that have been involved in organizations involved with atrocities. And I think they're actually quoting Joseph Witkoff, if I'm not mistaken, in terms of an article that he published where he made that same observation. Perhaps in a different context, though, with respect to international criminal law. The important thing I think that Zambelli underscores in terms of her research is the most problematical aspect in terms of exclusion, in fact, deals with complicity, or the non-direct forms in terms of perpetration of international crimes. And that would encompass things such as aiding, abetting, instigation, ordering, and being part of a joint criminal enterprise. And she points out that this is, in fact, complicity is, in fact, the most problematic area with respect to exclusion under Article 1FA. And that the joint criminal enterprise really calls for a number of key elements in terms of the analysis. And that would encompass a common plan in terms of the commission of the crime, participation in that plan, and the extent of the contribution in terms of how effective that particular plan was, and knowledge of the crime and the probable outcome in terms of that common plan. So these are all elements in terms of what should be encompassed with respect to an analysis on joint criminal enterprise. She also points out that all of this is really encompassed in the most seminal decision in Canada under Ramirez, where Justice Mark McGuigan analyzed this in detail and came up with the famous clause, if you will, of personal and knowing participation in persecutorial acts. And that's often quoted and cited in court judgments as well as IRB decisions. But he also made reference to being a member of a brutal, an organization that has limited and brutal purposes. And mere membership in those organizations could in fact result in a person being excluded. That is voluntary membership, of course. Now, keeping those particular studies in mind and contrasting those studies with what we've attempted to do in terms of our war crimes and refugee status research project, we have a number of objectives, and our objectives, the ones are perhaps more ambitious, but on the other hand, perhaps more focused and limited. And that is really... Should I stop here? Do you want me to...
Wrap it up.
I will.
We won't have enough time for discussion.
I will. Basically, what we're interested in is looking at whether or not Article 1FA is being applied as the drafters intended, and that is really applying international criminal law and international humanitarian law. So we're looking at the judgments to try to distill whether or not there's reference actually being made to IHL and ICL. The other is whether or not judges are in fact, or decision makers, are incorporating the UNHCR guidelines, which of course rely on these other branches of public international law. And perhaps the most ambitious portion in terms of our study is to try to discern through a detailed analysis, and we're looking at various qualitative methods of analyzing the data to see whether or not there's a common understanding across states in terms of the meaning of these branches of public international law. We've had various issues and concerns, and I'll go through these very quickly with you before I turn it over to Kate. But just to give you a sense of how detailed and difficult it's been actually to try to achieve these objectives in terms of this research. And a lot of credit has to go to Kate Jastrom in terms of this and the team at Berkeley, is developing a data collection instrument. We've actually been coding individual cases, and we're now at 64 pages with 91 variables. This is obviously a very complicated and detailed data set that we're trying to develop. Our Excel code sheet actually contains 845 rows that encompass all of those different variables. And we're looking at a cross-national study of 5 jurisdictions: Canada, the United States, United Kingdom, Australia, and New Zealand. So that gives you a sense in terms of how detailed this is. We spent a lot of time developing this data collection instrument. It has not been easy. And we've gone through a number of research assistants, so it's a training process. Familiarizing yourself with the data collection instrument alone is a daunting exercise. We have one of our researchers here today, and she perhaps can give you some insight. Katika can tell you that it's a very detailed instrument, and it takes some time to go through the cases. The other has been the serious challenge in terms of the identification of Article 1FA cases. And we're looking at all instances in terms of the refugee status determination process within Canada. That's IRB up to the Supreme Court. Our initial search using key terms on all of the commercially and online sites in terms of cases yielded something like 2,324 cases, but in effect, after going through this in detail, we found there are only something like 334 cases that are publicly accessible. We did not use access to information to gather those. So far, we've managed to code, and I'll stop here, Thomas. We've managed to code 92 cases, 7 at the IRB, 74 at the federal court, and 11 at the federal court of appeal. There are no cases at the Supreme Court of Canada. And I'm afraid I can't give you detailed information in terms of the breakdown of those. They're still with the Institute for Social Research, who's creating our SPSS data file, and the results aren't available. So thank you very much. I'm sorry for going over my time.
Okay. Ready for Kate? No?